The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Four cases will be submitted this afternoon. Russell Newhart versus Marcia Roll. Marcia Roll versus Russell Newhart. State of Iowa versus Shannon Breeden. And State of Iowa versus Tremaine Tolles. The last two cases are now submitted to the court without argument, and we'll proceed to hear the arguments in Newhart versus Roll. Mr. McCormick.
May it please the court, I'm representing Russell Newhall. Mr. Hanson represents Marcia Roll in this partition appeal. Partition in Iowa, as I'm sure the court knows, is governed by our rules of civil procedure. And I assert in my application for further review that those rules are statutory. They have the force of statute. Since then, I found a case, 1955 case, in which this court said that. It's a case involving a party called Hinder, H-I-N-D-E-R, against Reeser. And the court makes it clear that partition in Iowa is statutory within the meaning of the holdings that statutes are of legal force and effect. And that's important in this case because we have a Court of Appeals decision in which the court did not follow the applicable law. The Court of Appeals determined in the trial of this partition case that the defendant had met her burden not to establish partition in kind, that it was equitable and practicable, but that by application of a doctrine called OWLTY, O-W-E-L-T-Y, it was possible to equalize awards to the two parties in a way that they were treated the same. And the court did that on the basis of testimony that was given by appraisers for each party during the trial. According to the rules, the trial was supposed to be about whether or not there would be a partition sale or whether defendant could prevail in her contention that partition in kind was equitable and practicable, so that should be ordered. The district court found that the partition in kind would not be equitable or practicable, and on that basis determined that there should be a partition by sale. And as you know, partition by sale is the preference in Iowa. It may be the only state in the country where that is true, but it's been true here since 1943.
Counsel, as I look at that provision, I query whether there's really a strong preference for partition by sale, or whether that's just you have two options and one of them has to be said first, and so the first option is we'll sell it, divide the proceeds. The alternative option, equally worthy and possible, if one side says, well, I think we can divide this in kind, we'll do it that way, you have the burden to prove that it's equitable and practical. I mean, I guess my question is, in 1943, when this rule was adopted and we put the sale as the first option, was that an expression of a strong preference for sales, or was it just putting one option before the other in sequence?
I think it very clearly put the burden of proof on the party resisting a sale to first plead that it would be equitable and practicable to partition in kind, and then secondly, that the defendant had the burden of non-persuasion in establishing that. And I believe there's support for that in at least one of the court's more recent partition cases. Now, the common sense of it is that before the rule was adopted in 1943, there was a clear preference for partition in kind, and the burden of proof was on the plaintiff. It just seems obvious and common sense that what the court was attempting to do in submitting that rule to the legislature was to reverse that preference. And it really, I think, in the spirit of free alienation of real estate, adopted in Iowa this preference for sale.
Correct, Mr. McCormick, that we have kind of two levels of argument here. First is, as I take it, your argument that the court can do a partition in kind or it can do a partition by sale. But in this case, the Court of Appeals opted for door number 3, which was OLT, which is not an option under the rule. Is that
That's
line of
correct,
argument?
Your Honor. And not only did they go for option 3, they tried the partition case. They decided the issue of partition in kind instead of following the rules of procedure that a court is obliged to.
And the second line of argument is if we go back to just these first two options of partition in kind and partition by sale, your position is that Ms. Roll did not meet her burden to demonstrate that a partition in kind would be practicable. Is that
Yes, for all of the reasons that the district court gave, we believe the court at that level was correct in holding that the burden of proof was not met and that the partition here should be by sale.
Counsel, with respect to, let's assume, just for the sake of discussion, that a partition in kind was seriously considered by the court and not just rejected as the district court did. But my question is this. In this case, both Newhall and Roll told the district court, we want the Butler County farm. We don't want the Hardin County farm. Both Newhall and Hardin made a case as to why they were attached to the Butler County farm and not the Hardin County farm. And so it strikes me that maybe what the court was confronted with in assessing the equities is sort of competing claims based upon intangibles. Which of these two people has a more genuine attachment to the farm? Which of these people's claims to attachment is more profound, and why would it be more fair to give it to one than the other? I mean, that seems a difficult question for a court seeing an equity to struggle with, and maybe that was one of the reasons why the district court chose not to go that way. Is that?
It was not a reason the court gave, and I think what the reasons the court gave were adequate and sufficient and appropriate. And Newhall did not say, I want partition in kind. Roll said throughout, I want all this land partitioned. And that's what the Court of Appeals ended up doing. But the district court, for the reasons given by the judge, didn't have much confidence in the appraisal testimony that was given, determined that if Roll had her way and there ended up being partition in kind that would give Newhall the Hardin County property, that there was not an equitable or practicable way to partition the Butler County land. That seemed to me to be the essence of the decision. In fact, the court, when it confronted this O'Welty argument that the defense lawyer made, the court said, I don't think I've got authority to do it. And so the district court put its decision both on that level, lack of authority, and also the lack of practicability in the effort to divide the Hardin County land.
But we're reviewing this de novo, of course, and so even if the district court didn't confront that question that I posed about the competing claims of attachment, how should the court deal with that in a de novo review with equitable considerations?
You have to prove, if you were in the position that Mr. Hanson is in, that the partition in kind is practicable. And both the district court and court of appeals said it was not with respect to the Butler County land. And so a court of equity sitting in de novo review first has to determine what the facts are and then make the same determination. But it is not a case when there are equities of the nature that you mentioned that the court chooses which one of these people is more worthy, whose emotion is stronger and entitled to credit. In fact, if you look at the cases around the country, and I have, although I didn't do any briefing because we weren't given any for our argument here, if you look at the cases, they do not support the notion that income taxes and an attachment to the land, emotional attachment to the land, are sufficient reason to partition in kind. They say eventually this property is going to be sold. Somebody's going to have to pay the built-in gain when you have a low basis in this property. That's not something we're going to consider. So I think we're better off staying away from that.
But aren't those valid considerations? I guess you're taking the position that they're not. You just need to go with the equitable and practical. But I think all those things that you just mentioned, whether it's tax consequences, whether it's the diminution in farmland values, I think all these things should be considered as part of whether you can do it on a fair and equitable basis, don't you?
If one gets that far, I think that there are things that in Iowa haven't been ruled out. But I do think there are reasons why emotion ought to be kept out of the picture. The only Iowa case that I think I've seen where the court gave consideration to a party's preference was where the party had a homestead that would have been involved in a partition in kind, and the court believed that was an appropriate case for giving that party that portion of the property.
You know, we see equalization payments from time to time in marital dissolution cases, business dissolution. Does the rule here, can it be interpreted to allow for an equalization payment as part of a partition in kind?
Not if partition in kind is under a statute, which is the force of the rules of civil procedure. There's no provision in those rules for a OLT or a payment of that kind. It is used in other jurisdictions for that kind of purpose. But the significant thing is that in the states that do have OLT, you're going to find that there is a preference for partition in kind. And in those situations, they by statute or by some precedent are establishing a rule that there won't be a sale unless the property cannot be partitioned in kind or equalized by this OLT payment. We don't have that. If the court wants to change the rule, it would have to go to the legislature with its proposed change. The thing that the Court of Appeals did that's remarkable, I think here, is decide what would be an appropriate partition in kind. But the rules don't provide for that. In the sub-rules 1210 and 1215, they say that if the court finds partition in kind would be equitable and practicable, the court shall appoint 3 referees unless the parties agree on fewer than 3. And those 3 referees are charged with marking off the portion of the land, the parcel of land that would go to each of the parties in that process, and the referees then are to report that to the court. The significance of that is that our cases say that the referees are officers of the court. They're agents of the court. Whereas in this case, we had testimony from appraisers, but they were partisans. They represented the parties in this case, advocating and contending for the positions those parties wanted. So the Court of Appeals really did a short circuit on the rules if it believed that there should be partition in kind by not remanding and having the referees appointed and the partition in kind done. It simply was not done. I suppose the court saw a quick way to apparently dispose of the whole case, but it was a short circuit of the rules that should not have been done and should not have been prevented. The main thing is that the case, I think, has to be reversed because the court did err in adopting a doctrine that was never part of Iowa law, common law, never part of Iowa law historically in the rules or by statute, and is certainly not permitted or authorized under our rules under any rationale or any reading of those rules. They're to be interpreted like a statute would be interpreted. Courts don't make the law. Courts interpret the law. By interpreting the law here, I think there's no doubt but what the Court of Appeals erred in believing it had authority to equalize the payments by requiring one to make a monetary payment to the other to do what the Court of Appeals believed would equalize things. And it did it without permitting the regular process to be followed, which the statute requires, which would have involved the appointment of referees and letting them make the division in kind if there was to be a division in kind in this case. One thing that's overriding in our rules that I think was ignored by the Court of Appeals, where there is a partition in kind, it's supposed to be equally fair to both parties. And where you do have, as Justice Secretary mentioned, this preference by each party for a particular division, if there was a division in kind, one must, I think, recognize that that's not being equally fair to both sides, and that's why a partition sale was the right result in this case. Thank you.
Thank you as well, Mr. McCormick. And Mr. Hanson.
May it please the court. I guess, and I only suggest this is because my brother McCormick is somewhat new in this case, is that his review of the factual record is reflected to the court in his oral argument is incorrect. And it's incorrect because at no time in the transcript before or at no time during the proceedings did Mr. Newhall ever want anything other than the sale of the property. He never made any request that he be granted the property in Butler County. And the second thing that I think is appropriate to note is that if one takes any kind of look at these proceedings, this property was already partitioned in kind because one farm was in one county and one farm was in another county. The only
Is that quite correct? Or actually it was two cases originally, right?
Right, and they were
consolidated for purposes of trial, but you know, one could argue you still had two separate partition cases. So the issue would be, do you partition in kind or partition by sale the Butler property? And do you partition in kind or partition by sale the Hardin County property?
One could argue that, but no such argument was ever made in a
Well,
below or.
did one have to argue that? Because unless the cases were substantively, somehow the two properties were substantively consolidated, it strikes me you almost have two separate partition proceedings, and you needed to address them, each of the properties separately.
Well, I suggest that was not the case, the way the case was tried, Your Honor. And I also suggest that was not the way the case was appealed. It was appealed on the basis that there were two separate farms in two separate counties, and it was always the position of Marcia Roll that the plaintiff, Newhall, should be awarded the property in Hardin County, and she should be awarded the property in Butler County, subject only to its partition under the third prong of.
But that's almost argument like the rule says you have to partition the property that's subject to the case. And just because you combine the cases, it's sort of like, well, I'll throw in a piece of this property for that property. It's almost like the rule of OLT. When you say, well, I want this one, I want that one, it just doesn't make sense under the rules that you can combine cases and then start trading a property in case A for a property for case B.
Well, I guess that isn't the issue that I perceive to be what is raised by the appellant, or pardon me, the appellee before this court. I don't see that issue anywhere suggested in his application for further review. The case was tried as one case with two pieces of property, and it was argued that way to the Court of Appeals.
Are we supposed to ignore the statute because it was argued that way? I mean, are we going to let the way attorneys, and we always have this problem, are we going to let the way attorneys argue a case make the statute a nullity?
I'm not suggesting we make the statute a nullity, Your Honor. I'm suggesting that the way that this case was tried, which was the way the parties wanted it, the way it was suggested by the plaintiff in this case, which was Mr. Newhall, was that it was tried as one proceeding with two properties which he wanted sold. And the response was that we wanted, meaning the defendant, Marcia Roll, wanted only that the property in Hardin County be sold and that the property in Butler County be partitioned in kind.
But if it was tried outside the statute, what law are we supposed to apply?
Pardon?
If we find it was tried outside the statute or the rule, what law are we supposed to apply?
I think you have to apply the rules, Section 12, but if we want to just identify as to what Marcia Roll's position was, Marcia Roll's position was only the land in Butler County was to be partitioned in kind. That was her position at trial. That's been her position in both cases, and that's been her position on appeal. And if you look at it from that standpoint, the only issue is, can Butler County be partitioned in kind in an equitable and practicable way? And the answer is, yes, it can. It can quite easily because, as shown on Exhibit E, this is a portion of Exhibit E, in order to balance the difference between the values of the two farms, all one has to do is take the value of this 40-acre parcel up in the northeast corner of the Butler County farm and either transfer that physically by partition in kind to Mr. Newhall, or all it has to do is be sold, if you will, under the private sale provision, which is section 1222, parent 1 of the Rules of Civil Procedure as a private sale, sold to Mr. Newhall. And I guess that is the position that we've taken, because if we look at the balance of the proceeding in both counties, there is roughly 110 acres of hardened crop county that is row crop, and 50 acres that is in improved pasture. And in Butler County, there was 114 acres of row crop with around 200 acres of improved pasture, and this hay ground up here in the northeast corner. Now, the district court became somewhat, I think, confused about the testimony about this piece of ground, found that if this piece of ground were transferred to Mr. Newhall, there would be issues of, for instance, access. Access is always going to be the very same portion as it is today as it was at all times during this. And if the concern was value of property, Mr. Weirda, Newhall's expert, testified that this particular piece of ground was worth roughly $160,000, and Mr. Gannon testified $120,000. Mr. Gannon, in his testimony, would have equalized the difference between Hardin County and Butler County by granting more land on this side of the river. This is the Cedar River, north of the Cedar River, running down through the property, by giving that to Mr. Newhall if the court wanted to do a partition in kind and equalize it. But
Mr. Hanson, I mean, the district court found several reasons why that wouldn't work, as I recall. One was there was this creek that would have to be bridged. There would need to be fencing. There wasn't a secure water supply in the winter. And given that both parties said, I understand that Mr. Newhall wanted a sale, but he said, if it's going to be a partition in kind, then I want the Butler property. She can have. Both of them wanted that. Both of them had arguments that they or their daughter was engaged in family farming, and neither one wanted ownership of the other property. Given that, what's wrong with the district court's conclusion that it wasn't equitable or practicable to do a partition in kind? What's wrong with that result?
what was wrong with it, for instance, is when you talk about fencing over here, there hadn't been any cattle on this particular farm for 10 years or more. All right, that's number one. Number two, this ground up here was hay ground. Didn't need to be fenced because there weren't any cattle on it. And it was leased to a neighbor by Mr. Newhall and cash rented to a neighbor and had been for almost 8 years. And the problem here is that it was saleable. It's clearly saleable. It's not that this is a problem. The access problem that the court found was if you had to go across and take some land on the other side of the Cedar River, which was not suggested, then there would be an access problem, certainly, because you'd have to cross the river. But I'm just saying from a factual standpoint, those reasons, additional reasons that the district court gave, frankly, just didn't exist. He just didn't understand what the proposal was. And this, you can just see it here. I brought the exhibit, which was what Mr. Gannon testified to in terms of how he would balance the interests between the two properties. But the remedy, and indeed that's what Mr. McCormick has suggested, and which we suggested at the close of the trial in our post-trial brief, and what we suggested in our brief to the Court of Appeals was that if the court is concerned about the fairness of the allocation of parts of the Butler County farm to the plaintiff, then the court should have appointed the appraisers that are required, or pardon me, that are allowed in the statute. It's rules 1.1215 to 1.1218 for the partition of kind, and then make that decision. That is precisely what Marcia Roll had asked for before trial, and the court didn't rule on it.
Well, is it your position, counsel, that before the court could make the determination that partition in kind was not equitable and practical, that he needed to appoint referees to go out and suggest a partition in kind methodology?
No,
Okay.
I'm saying what he should have done was appoint those referees under the statute to make that determination, make that suggestion, and report to him. That is what the statute seems to require, pardon me, the rules seem to require.
Well, counsel, that's what I was trying to get you to address with my question. My question was, as I understand your position, before the district court made a determination about whether partition in kind was equitable and practical, he needed to appoint the referees to go out and make a report about whether it was equitable and practicable. Is that your?
No, I think it's just simply to do the latter. You can look at this and say, look, over here in Hardin County, you've got 110 acres, you've got 110 acres here of plow ground. Basically the same value. You have 50 acres of pasture over here in Hardin County, you have 50 acres of pasture over here in Butler County. How do we equalize the fact that there is more land in Butler County, and what the purpose of those referees is to do under the code is go out and make that determination of a partition in kind, because it clearly can be done. The land is there. You simply do that. That is what is typically the case in other partition cases, at least that I've handled. You have the appointment of the referees. You do it in advance of the trial. We asked for it in advance of this trial.
So I take it you sort of would agree with Mr. McCormick's observation that the Court of Appeals got way ahead of itself and made the determination without the involvement of referees.
I guess I don't think so, Your Honor, and I think because they made the initial determination that in fact there had been, that Marcia Roll had met her burden, which is a prima facie burden of showing that a division of this property in kind can be done equitably and practicably. And that, once she reaches that burden, then the Court of Appeals took the next step and said, we're going to avoid these other issues and we're going to make her pay cash to balance it. I think that OLT, if you want to call it that, is an equitable remedy. There is nothing in our rules that forbids that equitable remedy. And
Counsel, what language in the rule permits a cash equalization payment?
I would suggest to you, Your Honor, that it can easily be characterized as a private sale, which is under Rule 1.1222, parent 1, and the court can make that, order that private sale. It doesn't have to be at fair market value. The rule specifically says so. And I also think it's just a general equitable power of the court in these proceedings, Your Honor. But I do agree that there's no specific rule that talks about it. Thank you.
Thank you, Mr. Hanson. Rebuttal, Mr. McCormick?
Mr. Hanson suggested that I had not read the record to see that my client, Mr. Newhall, had said if there was to be a partition in kind, he wanted the Butler County property. I suggest to you, if you look at Mr. Hanson's cross-examination of Mr. Newhall, you will see him say there something to the effect, Mr. Newhall, if the situations were reversed and you were to get the Butler County property except for the 70 acres or the $75,000 and Mrs. Roll would take the Hardin County property, would you think that would be fair? He said yes. So in any event, I think that was an expression of his interest, if there was a partition in kind, to have a preference for the portion of the Butler County land that Mrs. Roll wanted. The second thing was, I think, a very useful question that was asked about whether or not this was not actually two partition cases, because that's the way they started out, and that's the way they ended up. And if you look at the pleadings, the answers had already been filed in those two partition cases by Mr. Hanson, whoever the lawyer was at that time. And the answers in each case asked that the two county properties be partitioned in kind. And that was never changed throughout this trial. In fact, if you look carefully at the document that Mr. Hanson filed in which he made his argument after the case had been fully submitted, he never asked for sale of the Hardin County land. What he said was, if you give that to Mr. Newhall, he can sell it because he doesn't care about it, and then he can pocket the money. And then he suggests here today, well, Mr. Newhall could have sold that pasture land up on the north side of Butler County if he was given that also. But both the district court and the Court of Appeals said that that was not an appropriate thing to do. And they said it not just for the reasons Mr. Hanson discussed, but because it would result in an uneconomical unit. It would make it difficult to sell and would affect its value. And of course, they also said it would affect the value of the rest of the Butler County land. But in any event, they never asked for what Mr. Hanson has suggested here today that they were seeking. They always took the position that both of these lands, both of these farms, must be partitioned in kind, and it was only because they said, well, you give this one by partition in kind in Hardin County to Mr. Newhall, he can go ahead and sell it because he wants a sale. I think you will find nowhere in the filings or in any argument that was made to the court was there any suggestion that there be a sale of the Hardin County property. Thank you.
Thank you as well, Mr. McCormick. The case then is now submitted, and we'll next hear the arguments in Roll versus Newhall.